Welcome to Law and Democracy, a podcast of the election law program at The Ohio State University. I am Steve Huffner, the Deputy Director of the Election Law Program, and I'm joined today by Ned Foley, the Director of our program, who is spending the fall in a fellowship at Princeton University. But we're delighted to welcome Ned to our conversation today, as well as Anthony Goguen, who is a visiting faculty member at The Ohio State University Moritz College of Law this year, and the Kern Family Professor of Law at Drake University Law School. Tony and Ned, it's good to see each of you today. What are we talking about today? No, thanks, Tony.
Steve, our first topic is Robert Kennedy's ballot problems. Kennedy began the presidential race as a candidate for the Democratic nomination, as we'll all recall, but then he mounted an independent campaign for president beginning last fall, and he fought for months to get on the ballot in states across the country. And now he has suspended his campaign and declared his support for the Republican nominee, Donald Trump. But the problem is Kennedy is having a hard time getting off the ballot in many battleground states, ironically, including Wisconsin, Michigan, and North Carolina. So the starting point for our first discussion topic is, what do we make of Kennedy's problems getting off the ballot in key states?
Sure. So, I guess an initial thought that I have is that election administration is always a logistical process that can be a little bit complicated and involves a number of steps. And some of those steps are quite substantively significant, including whatever process the state uses to decide who can be on their ballot. You can't just declare a day or a week or even a month before election day that you want to run. That could make our ballots unwieldy. So states have made judgments about how one qualifies to be on a ballot, whether it's by being nominated by a recognized political party or by collecting signatures that show a critical level of basic support, and that has to be done in time for the election officials to then prepare ballots. Prepare ballots not only for election day voters, but prepare ballots for early voters, and in particular, prepare ballots for overseas military voters for whom balloting materials are required by federal law to be on their way abroad by 45 days before election day. So that's sort of the front end of getting on the ballot. Well, and then sort of the back end of that is, for similar logistical reasons, states have to at some point go final with what their ballot looks like, and not be continuing to adjust and adapt and modify all the different ballot styles that they're having to prepare and, in electronic voting circumstances, test well in advance of election day. So those are the logistics behind what the various state laws provide, and that, I think, is in some fundamental sense what Robert F. Kennedy Jr. has run up against.
And if I can add sort of 2 points to what Steve just said, I wonder to what extent the extra difficulty of getting off the ballot here is a factor that this is a presidential election and not an election for governor, senator, or other office. As we discussed previously, the rules for presidential elections are especially complicated, more so than other elections, because of our electoral college system. So when we talk about candidates, presidential candidates getting on the ballot for the November vote, that's actually a shorthand for a political party qualifying for the ballot its slate of electors who are pledged to nominate, who pledged to vote for president. If they are chosen as the state's electors, they're pledged to make their electoral vote for the party's candidate. So it's not really Kennedy's candidacy, it's the candidacy of his party. And he's an especially complicated figure because he was put on the ballot in different states pursuant to different parties. It's not like, Kamala Harris is the nominee of the Democratic Party in every state and Trump is the nominee of the Republican Party. in every state. Kennedy has cobbled together ballot access in different states through different minor party vehicles, some of which none of us have really heard of. But from a legal perspective, it's the party that gets on the ballot for its slate of electors. And so Kennedy's not really legally entitled to withdraw. The party has to make the decision to withdraw. And I noticed at least one judicial opinion refusing his request relied on the point that the party wasn't joining his application. And then the second thing I would say, which I think is a broader point that we may or may not want to discuss today or in the future, it's troubled me for a long time, the fact that our presidential election process, and this point is true of other offices, but it's especially acute in the context of the presidency, which is such an important office, does not have a rationally constructed system to yield a single winner from a field of multiple candidates who want that office. The founders, in creating the electoral college system, wanted the majority principle to govern presidential electors. We know that from several sources. One is the Constitution itself says you need a majority of electoral votes to win. And if you don't get a majority of electoral votes, it goes to the House of Representatives, where you need a majority of the states. And in the debates, they thought about whether those provisions should not be a majority requirement, but in fact, what's called a plurality requirement, simply more votes than anybody else. And they emphatically rejected the idea of a plurality winner for the presidency. They thought it was essential that the chief executive of the United States have majority support under the system that they constructed. But the system that we now live under, that is evolved, it has part of its component, what the founders created, and another part of its component are the implementing state laws that have grown up in the aftermath of that. And the plurality principle, instead of the majority principle, has taken over at the level of state law, which means you can win all of a state's electoral votes with only a plurality of the popular vote, not a majority. And if there are more than two candidates, the votes can be split 3 ways or 4 ways or 5 ways where nobody gets a majority. And so, Robert Kennedy's status as a candidate, or really any third party or independent candidacy, is an afterthought. The founders, when adopting the 12th Amendment to the Constitution, which is the part of the Constitution that creates the Electoral College that we have today, thought there was only going to be two-party competition, because that's what immediately developed in the aftermath of the original Constitution, where they had hoped there wouldn't be any parties. Well, that didn't work out, and we had intense two-party competition. But they didn't create rules or a structure for what would happen if there was significant third-party competition in such a way that if the state laws allowed for plurality winners at the state level, that would destroy the majority principle that the founders wanted. And we've never fixed this. And it is a real Achilles heel that has caused serious problems in the past, which we could talk about if we want to, and it potentially could cause a problem this year. And so whether he's on the ballot or not on the ballot, our system doesn't handle third candidates very well.
But
Yeah,
it's that.
go ahead. Oh, I was just going to say, on that very point that Ned just made, one of the great ironies of Kennedy's campaign is that he's a spoiler who doesn't want to be a spoiler. Regardless of what you think about his position on the issues, I think he does deserve credit for the fact that he's trying to clear the way so that you can have a majority winner in these various battleground states. And yet the system, the way it works, prevents him from doing that, from making it possible to have the type of electoral college majority that you've been discussing, Ned. So to me, it's a reflection again of how the electoral system itself is so complex. Even the candidates themselves have a limited ability to influence it, especially as you get late in an election cycle where ballots are getting ready to be printed and where, as you said, we've got slate of electors already identified by the party. So there's a real irony in the Kennedy story, it seems to me.
And I was going to make a similar point, which is, the reason that Robert F. Kennedy Jr. would like to take his name off of the ballot in some of the critical battleground states is precisely because those states are likely to be very closely contested. And with his name still on the ballot, it might be that the outcome is determined by just a plurality. And if he could get his name off the ballot, it might make it easier for it to be a majority winner election in that closely contested state. Of course, all of this relates to your general point, Ned, about this sort of fundamental flaw in how most states have operationalized their responsibility to determine how to pick their presidential electors. And of course, one possible alternative would be for states to require majority winners in those elections. And that could be done in a variety of different ways, as you've often written about. So the Robert F. Kennedy example right now, and the fact that he still wants to be on the ballot in all the states that aren't the swing states, he'd like to be able to show for the future that he received however many votes he is able to receive in those other states. And he's only asking to come off the ballot in what are the swing states. But his example is an opportune time to think about the majority winner problem and whether to require runoffs, which would really be kind of unworkable at a presidential level. I mean, Georgia uses runoffs to get majority winners for their Senate and other races, but we've seen it in the U.S. Senate. And they're not the only state, but they're just a tiny number that do. Of course, ranked choice voting is itself often offered up as a response to the spoiler effect problem. That we can avoid third-party candidates functioning effectively as nothing but a spoiler if we let voters express a ranking preference for their candidates and insist on coming up with a majority winner in the end.
Right, and both Maine and Alaska are two states that use that kind of ranked choice voting for the appointment of their presidential electors. So states have the power to do this. Two states are already doing it, but only two. If every state used a ranked choice ballot, there wouldn't be a spoiler problem, as Steve, as you're absolutely correctly saying. But states, other states haven't attempted that. I agree. I don't think it's possible to hold a runoff after the November vote under federal law because states have to appoint their electors
for president. Yeah, the runoff.
On the date, but states could, if they didn't want to use a ranked ballot, but wanted a two-round system that ended up with a majority because you only had two candidates on the ballot in November, they could hold a preliminary vote like right around the beginning of September, and with all the other candidates on the ballot and just have a top two. It's like California's top two system. You could apply that in the presidential election after the parties have their conventions that they've already had and say, we've got lots of candidates on the preliminary ballot, but we'll only have two candidates, meaning two slates of electors that are eligible in November. And so you could comply with the federal calendar, the congressional deadlines, but yield a majority result if you did it. Now, that would require an extra round of voting. The beauty of a ranked choice ballot is you only have to cast it once, and it functions equivalently as an instant runoff. Another term that is often used in connection with ranked choice voting is an instant runoff because of the kind of procedure that Alaska and Maine uses with their ranked ballots. But either way, I'm certainly on record and a big believer in the majority principle, and even if Kennedy deserves credit in trying to get off the ballot and not being a spoiler in the swing states, there are other candidates besides Kennedy this year who could be spoilers.
Still on those ballots. Yeah.
Harris and Trump are not the only two in the swing states and other states. And so we could end up with a spoiler problem and a plurality result, even if Kennedy were successful here.
And certainly France gives us an example of a country that has a multi-stage presidential election process that has worked for them. And the other aspect of this that strikes me is just that Kennedy is the son of course, Senator Robert Kennedy of New York, who ran for president in 1968 and, of course, was tragically assassinated. One of the really interesting aspects of that election, it's often forgotten, the Humphrey-Nixon race in 68, is that there was a third-party candidate in that race, George Wallace, who almost was a spoiler for Nixon, handing the race to Hubert Humphrey. And I know some historians believe that Wallace's selection of General Curtis bombs away LeMay saved Nixon because Wallace was running stronger in the polls in the summer of 68 until he picked General LeMay, and then he came in something like 13%, getting 13% of the vote or thereabouts, and presumably that was all coming from Nixon. But if he'd been at 17, 18, 19%, that might have been enough to put Hubert Humphrey over the top in 68. So there are echoes of an earlier Kennedy election year this year.
Yeah. Oh, that's a very nice point. I mean, our history has some examples of significant third-party candidates, some of whom, if we use the term spoiler to mean made the difference in the outcome, didn't just get votes, but got votes in such a way that we can pretty much tell that had that candidate not been in the race, a different winner would have been declared. Then I think you're right that Wallace was not a spoiler that year. Nixon would have won if it had been just a straight up Humphrey-Nixon race without Wallace on the ballot. But Ralph Nader in 2000, I think, is an example where most political scientists are confident that he did play that spoiler role. And indeed, that's why ranked choice voting has gotten a lot of attention in the last 20 years, is specifically in response to the role that Ralph Nader played in 2000. And if we want to go back to the 19th century, I think the most consequential spoiler occurred in the election of 1844, which I never learned about in high school or college, but set us on the road to the Civil War because a pro-slavery candidate won, expanding slavery out west and into Texas and into other states, ending the Missouri Compromise, and really destabilized our country. The elections have consequences, and the rules of elections have consequences when they allow for a spoiler problem to exist.
Well, our second topic for today is from one of the states where Kennedy is trying to get off the ballot. A Pennsylvania court ruled last week that the state constitution requires the Philadelphia and Allegheny County election boards to accept timely but undated or misstated mail-in ballots, despite a state law to the contrary. As a number of legal scholars have pointed out, the ruling raises questions whether its application to the federal elections in Pennsylvania could run afoul of the independent state legislature theory, to the extent that the theory survived the Supreme Court's 2023 holding in Moore v. Harper, in which the court held that the word legislature in Article 1's Elections Clause does not insulate state legislatures from the ordinary exercise of state judicial review for violations of state constitutional constraints on lawmaking. It also raises a potential equal protection issue under Bush v. Gore to the extent that the mail-in ballot ruling only applies to 2 of the state's 67 counties. So the starting point for our second topic is whether the Pennsylvania ruling does indeed run afoul of the Elections Clause or Bush v. Gore.
Yeah, I mean, both of those are really interesting problems. They both involve trying to figure out what significant Supreme Court precedent involving election law might mean in some slightly different context. And of course, in Moore versus Harper, there was a sense that on its face, it was rejecting the notion that legislatures had independent and unreviewable authority to establish their manner of conducting federal elections. But a close reading of that case made apparent that some subsequent case could involve the court looking at what ordinary judicial review was. And in this case is the Pennsylvania Supreme Court's decision about what the Pennsylvania Constitution requires when it's flatly different from what the legislature has said by statute. It could be an opportunity for the U.S. Supreme Court to try to define a little more specifically what ordinary judicial review is. I mean, I suppose at some fundamental level, because it's a state Supreme Court interpreting its state constitution, that looks ordinary. But who knows when what's at issue is the elections clause. And, similarly, Bush versus Gore created this new equal protection principle that in that case said all Florida counties were going to have to use the same standards to recount their 2000 presidential ballots in the 2000 election. And you sort of wonder why the Pennsylvania Supreme Court wasn't more attentive to that in saying that their mandate that just 2 counties treat these absentee ballots this way. Anyway, do you have thoughts about why the Pennsylvania Supreme Court?
Well, it's the Pennsylvania Appeals Court, right? I think I don't think it has gone up to the Pennsylvania Supreme Court yet.
I'm sorry.
It was a court of original jurisdiction, a 5-judge court of original jurisdiction heard the case.
Yeah. So I think there's an open question what the Pennsylvania Supreme Court will do with this case. And I'm not willing to make a prediction on that. I am willing to go out on a limb and predict that if the Pennsylvania Supreme Court affirms this decision, that the U.S. Supreme Court will reverse. I'm not sure what ground, and we can get into that. I think, and I should preface my prediction as a policy matter, I think the rule is a bad rule. I think it's a gotcha, right? I mean, as long as ballots arrive under the deadline, it shouldn't matter whether they were correctly dated or not. We know they were cast in time if they were postmarked in time and arrived on time. So there's no substantive flaw with these ballots that may be disqualified. So I'm sympathetic with the impetus of any court that kind of wants to protect voters from a gotcha rule. On the other hand, rules are rules, and it's really important that elections be conducted according to the rules and clear rules, and that the rules don't get changed late in the game. And so one prediction, or tentative prediction, is that the so-called Purcell principle that we've discussed previously might apply here, that the ruling that we're talking about is pretty close to the election itself, especially the time that mail ballots start to be available, which is obviously significantly before November 5th. So I could see the U.S. Supreme Court ducking the merits of the Moore versus Harper issue or the equal protection issue by saying on timing grounds, this decision comes too late. What would be novel is the extension of Purcell to a state court ruling, as opposed to the Purcell as a technical doctrine of federal court procedure has come up in the context of federal court litigation. This is coming from state court, so that would be novel. But I could see the U.S. Supreme Court trying to devise a timing argument that's more tentative or more qualified than a full-on substantive ruling. If the court was willing to do a full-on substantive ruling, I do think they'll go the Moore versus Harper route and not the equal protection route. And this gets us into a little bit into the history of Bush versus Gore itself. In that case involving the 2000 election, there was a difference among the so-called conservative justices about whether to rely on the Article 2 argument that the state courts were depriving the state legislature of its federal constitutional authority to make the rules for the appointment of electors. And three of the conservative justices wanted to rely on that, the more conservative justices, Rehnquist, Thomas, and Scalia, whereas the two moderate conservatives at the time, Justices O'Connor and Kennedy, balked at this so-called Article 2 or independent state legislature argument, or whatever you want to call it, and they settled on equal protection. And we understand from subsequent discussion that's come out among historians of that decision that the three conservatives went along with the equal protection ruling, not because they really liked it, but they wanted, in the fast-moving litigation that occurred, to have 5 members of the court agreeing on something for the disposition of the case, the controversial ruling in a presidential election. And my guess is that the current court, being more conservative, being more attuned with that philosophy, this would give them an opportunity to kind of revitalize Article 2 for these kind of cases and maybe downplay the potential role of equal protection in this context.
Yeah, I have the same sense, Ned, and I'm very intrigued by the possibility that the court would extend the Purcell principle to state courts, to state high courts. And I'm curious, what do you think would be the constitutional hook, the federal constitutional hook that would empower the U.S. Supreme Court asserting appellate jurisdiction over a state high court to say the federal constitution prevents you from interpreting your state constitution on the eve of a federal election?
Yeah, it's a really good question. I haven't fully thought it through. I wonder whether there's some kind of, the one thing that we know that where there's federal supremacy in the context of presidential elections is the timing and the calendar of it. And so I wonder if the court could come up with a kind of implied preemption doctrine saying that to the extent that states adjust their own deadlines with respect to presidential elections that destabilize the election process, that's interfering on Congress's turf over presidential elections. Yes, the state gets to control the substantive rules, but they can't monkey around with the timing. The easiest way to see that working is if a state legislature tried to change the rules after the ballots are cast, that I think is undoubtedly a no-no, whether you call it a due process retroactivity problem or an Article 2 problem or something. But it's harder to make that same point when the state is playing around with what's happening before the appointment of the electors. But so they may feel like they just can't go that route. But I think they're going to be upset both with I think again, not that I believe this, but I think the conservatives on the court will think this is an abuse of judicial power. The legislature made rules for how to govern the electoral process. You may not like the rules, you might have wanted different rules, but these are the rules. And the federal constitution gives that power to the state legislature. If there was a clear provision of the Pennsylvania Constitution that was undeniable that the state legislature was violating it, I think most of the conservatives on the Supreme Court would say, okay, that's normal judicial review. We've got absolute clarity from the highest source of Pennsylvania law that you've got to do it this way. So that should prevail. But the provision that as I understand it, the provision that the court relied on here is a very vague and amorphous provision. Pennsylvania, like some other states, has a provision that says the Constitution of Pennsylvania wants free and fair elections. Don't we all? The question is, what counts as a free and fair election? And is it really true that the state legislature's choice of this particular rule, denies a completely free and fair election? Again, it's not, I think it's a stupid rule. I think it's a gotcha, but does it really, does it go to the point of denying a free and fair election? And I think the conservatives could say the judges on this Pennsylvania court are substituting their policy preference on how to run elections for the legislature. And when it's a policy preference, it belongs to the legislature, not the courts. And so that would be coming down pretty hard and emphatically on the substance of this and deflecting the timing Purcell point. And I think they'll at least want to ask themselves whether they can construct a Purcell timing point, which would be a softer ruling, but it may not be available to them.
So given all of that, which all makes quite a bit of sense, what do you think the Pennsylvania Supreme Court is likely to do with the intermediate appellate court's decision?
Yeah, it's
Tony,
fascinating.
I don't know that court well enough. Tony, do you have?
Oh, I don't. But I do think it's interesting that the 5-judge panel's opinion is over 100 pages. And sometimes my sense is the longer an opinion, there can be less confidence on the part of the judges that their reasoning is sound. So maybe there's an indicator there, Steve, along the lines of your question, that maybe those 5 judges or the 4 judges in the majority have some doubts themselves by the fact that they had to wrap that holding in such a dense amount of paper to defend it.
I think the one thing that's relevant here, or one thing that is relevant here, is the history of the tussle between the Pennsylvania Supreme Court and the U.S. Supreme Court back in 2020. It involved a different issue involving absentee ballots. There, it was whether or not there would be some extra days because of COVID, but quite similar in terms of what's in front of the Pennsylvania Supreme Court now. And the U.S. Supreme Court was able to deflect the issue because it turned out that there weren't enough of those ballots to make a difference in the outcome of the election. Biden won Pennsylvania by, I think, around 80,000 votes, if memory serves, and there are only 2,000 or 3,000 ballots that were affected by the extension of the deadline that the Pennsylvania Supreme Court gave. But the Pennsylvania Supreme Court divided 3-2 along party lines in that case, and I thought that, I mean, some of the justices on the Supreme Court were sending explicit signals like, no, we're not going to tolerate this. This was right at the time that Justice Barrett was coming on the court after Justice Ginsburg's death, and I think the Supreme Court, U.S. Supreme Court, didn't want to get into a super ugly fight that was unnecessary. But I personally read the Moore versus Harper case, even though it came out of North Carolina, and even though it involved redistricting and not absentee ballots, as sending a primary signal to the Pennsylvania Supreme Court, we're watching you, and you're on probation, and don't do again what you did before. And, whether the Pennsylvania Supreme Court heeds that lesson, I don't know. Clearly, the lower Pennsylvania court didn't want to heed that lesson, or wasn't going to for whatever reason. But I would think the Pennsylvania Supreme Court is aware that it's under the microscope on this one, and would need to feel very careful about how it proceeds.
Well, when the Pennsylvania Supreme Court rules, we will definitely revisit this topic. Speaking of topics, our final topic for today arises from the ballot initiative process. Voters in Ohio and Utah have pushed for redistricting reform to ban partisan gerrymandering in their states, and they have turned to the ballot initiative process to achieve that goal. But in both states, election administrators have placed language on the ballot that could easily confuse and even deceive voters. In Ohio's case, the ballot board's approved language includes a claim that the initiative to ban gerrymandering would instead promote it. Similarly, in Utah, a constitutional amendment proposed by the legislature to weaken the constitutional effect of voter ballot initiatives is instead described in the ballot as a measure for strengthening the initiative process. So the question to kick off our discussion of our final topic today is, what do we make of what's going on in Ohio and Utah, and what does it say about the choices that state administrators face when drafting and approving ballot language?
Well, I see it as indicative of several things. I mean, one of them is that choices about election law can quite easily have dramatic effects on election outcomes. The process matters. That's sort of one obvious takeaway. But and because of that, another one is just how unfortunate it is that so many dimensions of our election administration systems in each of our states are subject to partisan control. I know at a fundamental level in every state, we attempt to structure our elections so that they're bipartisanly administered. And so each of the two major political parties can kind of act as a watchdog against the other. But there are nonetheless ways in which the majority party of a state has outsized influence, including the fact that in most states it's an elected Secretary of State who's the chief elections officer. And getting back to these two examples, that there are processes in place in many states where it's a partisan decision, or it's a decision of a partisan body, is a better way to put it, how ballot measures are characterized for what is ostensibly the purpose of making it easier for your average citizen to understand what's going on. And when those ballot summaries that again are ostensibly supposed to permit average voters to understand what they're being asked to vote on without having to read all the legalese that is the measure itself, don't fairly reflect what the measure would do in the eyes of any neutral observer, we've got a real problem of democratic government, democratic choice.
Absolutely. I mean, I think if James Madison is looking down on what's happening here, he'd be very disappointed. I mean, our system of government, our Republican system of government, is supposed to allow the people to engage in self-rule, self-government. We have institutions and procedures to do that. Madison knew that men were not angels and our institutions wouldn't be perfect and human virtue isn't angelic, but our founders wanted the system to work and to work in the public interest. And they wanted to design a government so that no party or faction, to use their term, would take control of the government for its narrow self-interest. Now, they didn't design the ballot initiative mechanisms that have come into favor in some states like Ohio and Utah, and about half the states have this mechanism. It tends to be an innovation from the progressive era. You know, for a period of time, people were worried that there was kind of misuse of these ballot initiative processes by special interest groups and moneyed interests. And California, for example, famously had too many of these ballot measures. And so again, as a people, we're searching for the best way to engage in self-government. But my current judgment, if we look at the states that either have this mechanism or don't, states are better off if they have this mechanism, because it does give them, as it was supposed to do, give the people an outlet to complain if the government itself isn't being sufficiently responsive to their needs. And the Ohio example, which I'm more familiar with than the Utah example, this is a clear case, in my view, of where the people want something and say that they want something, and that politicians holding power want to deprive the people of what they want, and are misusing the process, abusing the process that is supposed to yield collective self-government. And the specifics here involves the concept of gerrymandering, which is, as I'm sure many of our audience know, is when district lines are distorted, again, for partisan advantage. The citizens of Ohio tried to stop gerrymandering by going to the ballot with ballot measures twice before to set up a mechanism to do that. And the particular details of that proposal didn't work. So they're trying to go back to the ballot and really stop gerrymandering, because it's gotten worse and worse and worse in the state of Ohio. And the politicians who have benefited from gerrymandering, and their political party that is done, doesn't want to give up that power and that extra advantage. And so they are really, again, I guess everybody's entitled to their opinion, but my opinion is they're not acting in good faith in changing the language of the anti-gerrymandering provision that everybody understands it was designed to stop gerrymandering, and for the language to go on the ballot that this proposal is to make gerrymandering worse is just antithetical to what this is all about. So it's a really sad commentary, I think, on the state of democracy, and at least and it now appears this is not just an isolated incident in one state, but in a couple of states.
And I think the whole problem of partisan election administration is another example of why it's so difficult for courts to stay out of issues that maybe historically they would have, but when you see the democratic process, small d, democratic process being undermined, it is incumbent upon the courts at some point to intervene, even when they wouldn't like to. And I know in the Utah case, Steve, you know more about this than any of us, the Utah Supreme Court had actually issued a ruling just a couple months ago upholding the power of the ballot initiative process. And maybe you could discuss that, give us some of the background on that.
You know, I was thinking the way in which Ned characterized the problem was quite a fair characterization of what's going on in Utah at the moment. But there is this fascinating difference between Utah and Ohio in that Utah voters lack an initiative process to amend the state constitution. In Ohio, voters can use the initiative process to change our state constitution, and that's what had happened in 2016 and 2018. And the measure that's now before voters again this fall would change that system as expressed in the Constitution. In Utah, voters several years ago used a statutory initiative to change the way in which legislative districts were drawn in the state. And because it was a statutory initiative and not a constitutional initiative, it was relatively easy for the legislature itself to then just amend the statute and say, we don't like what the voters have done. We're going to insist that gerrymandering or that districting continue to be done in a different way. That went before the Utah Supreme Court. And the Utah Supreme Court essentially said, and I'm paraphrasing this, that that the legislature and the citizens of the state were co-equal in their ability to make law. And they derived that from the state constitution. And that when the voters, using the statutory initiative process, have adopted a new law, the legislature needed to be essentially, and this is my paraphrasing, more respectful of what the voters had done. And that the legislature could only undo what voters had done by statute if what the voters were doing was some kind of adjustment to the fundamental structure of the democracy in the state, that if given that precondition, that what was at stake was the basic operation of state government processes, the legislature couldn't change that unless the legislature could essentially pass a compelling interest test. There's a sort of fascinating wrinkle on the relationship between a statutory initiative adopted by the voters and the legislature's, basic power to change statutory law. That in that particular area carved out by the Utah Supreme Court as involving core functions, core structural features of the state government, the legislature had to respect what the voters had done absent a compelling interest. Well, the legislature didn't like that Supreme Court decision. This was a decision of 5 justices of the Utah Supreme Court who've all been appointed by Republican governors. And it was a unanimous Utah Supreme Court decision. But the legislature is essentially now putting on the ballot a measure that would override the state Supreme Court's constitutional decision. And the legislature can put on the ballot a constitutional amendment that, if adopted, would then wipe out the state Supreme Court decision. And that measure is being described in the ballot language that was just adopted, I think, at the beginning of this week, as a measure to strengthen the initiative process, among other misrepresentations.
So I have a question for both of you on this topic. I am not a deep scholar of the initiative procedures, whether they're statutory or constitutional. I mean, I'm obviously aware of them, but it does strike me in these examples, there's a fundamental question here of who should ultimately control the explanation of these measures. Should it be that the authors of the measure, the citizens that wanted, who gathered the signatures, so on and so forth, when it's a citizens initiative, maybe it's when it's the legislature putting their own initiative on the ballot, they're the author and should control it? Or should a ballot board, as in Ohio, get to control it? It seems to me there does need to be some check on the language to make sure that it's not misleading or inaccurate or abusive. But I think it's a genuine question, like, who gets to make the final decision when there's a debate over what the language should be?
Well, and we've had this issue percolating throughout the existence of our election law program. This question about partisanship in election administration, as opposed to having what would be typical in most other democracies today. Most other representative democracies have some kind of professional administrators who might perform these functions. And in other contexts, we too have sometimes talked about the advantages of having nonpartisan professional administrative bodies doing more of these things. But that is a departure from the culture with which elections in the United States have come to be conducted. And it's why I began this particular topic today by saying it's another example of how we are mired in circumstances in which partisanship can have, in some circumstances, an improper influence.
Right, and that's a hugely important point. And there are some aspects of election administration that government officials inevitably have to be the ones to make the decisions, whether they're partisan officials or nonpartisan officials or so forth. But at least for the kind of thing that's happening here in Ohio, where it's a group of citizens have gathered signatures to put on the ballot their proposal to undo what they don't like the government doing. Why not let them be the ones to say what the explanation of their own proposal is, subject to some kind of, fair review process, whether it's in a court or not, as opposed to to what's going on here, where the rewrite is topsy-turvy, makes it the opposite of what it's supposed to be.
There are a number of states, or at least some states, that permit the proponents of ballot measures as well as their principal opponents to each be able to prepare a statement about the pros or the cons of adopting the measure. And that those collected representations are then distributed to all voters in a voter guide. Now, that's not quite the same thing as preparing the actual ballot language that's on the ballot, but it's certainly a relevant source of information. And to let the proponents be able to characterize what their measure would do, at least in that sense, would be a helpful improvement, I think.
There's an old saying that truth is the first casualty of war. And I think we can amend that statement to say that truth is also the first casualty of partisanship. And in this case, I think part of the problem is just a lack of civility, that if there was a broader commitment across partisan lines to truth and honest descriptions of certain things and a limitation on relentless partisan spin, I think that would be a major step towards improving the quality of discourse overall. But we're in an era where everyone's perspective is so subjective. And of course, that's always true at a certain point, but there's not even a sense of honor that I've got a duty to be objective in a certain way as a public official when it comes to ensuring the public understands what's on the ballot. And so I think there's a civility component to this, which if we could restore a sense of civility more broadly in the country, it will eventually get to our elected officials that we expect and demand of them, that they're going to achieve at least a basic standard of honesty and transparency in public discourse.
Yeah, I echo that. I mean, I applaud you, Tony, for saying that. I think adding to civility, I would say fair play. I think, again, democracy is entitled to be competitive. Parties are entitled to want to win. But unless there's some modicum of sense of fair play or honor, as you use, you can't play the game at all, right? And I think the books by Levitsky and Ziblatt that came out a few years ago, these are two political scientists who looked at the decline of democracy all around the world. I think it was called How Democracies Die. I think they identified as the need for forbearance, if I remember their term. Like you can't push everything to the last ounce of competitiveness. There has to be some willingness to engage in honest interaction with the opposing side, I think.
So I think we've come to the point where we need to begin to wrap up, but we have some trivia to tackle, I think, don't we, Tony?
We sure do, Steve. It's definitely time for this week's trivia question reveal. For those of you who don't know what this week's question is, I'll just quickly give you the background to it. The president, as everyone knows, is elected by the Electoral College, not by a nationwide popular vote. But the popular vote is immensely important in each state, especially, of course, in battleground states where razor-thin margins can determine who wins the electoral votes in that particular state. The closest presidential race of the 21st century was the Bush v. Gore race, which we discussed earlier today. George Bush's Electoral College majority in 2000 was achieved on the basis of his 537 vote margin in Florida. So our trivia question for this week is, what was the closest battlefield state popular vote margin to determine an Electoral College majority in the 20th century? And so, Ned and Steve, I know you both know the answer to this. Does one of you want to do the reveal?
Oh, no, Tony, you do it.
Oh, okay, with my Minnesota accent, I'm going to have to be careful to enunciate because the answer is 1916, not 1960, as many may have guessed. Of course, the John Kennedy, Richard Nixon presidential race in 1960 was exceptionally close. But as it turns out, the Woodrow Wilson, Charles Evans Hughes race, which I'm sure everybody remembers from 108 years ago, was even closer. Wilson's electoral college victory over Hughes that year rested on his victories in New Hampshire, North Dakota, and New Mexico, which he won by a cumulative total of 4,387 votes out of about 18 million votes cast nationwide. So Wilson, his victory over Hughes, is the race of the 20th century. And Charles Evans Hughes, the loser in that race, did end up with a pretty good consolation prize, which was he eventually became Chief Justice of the United States Supreme Court. And that gives rise to our trivia question for next week, which is about Supreme Court justices as candidates in or as candidates in presidential campaigns. So as I said, New York Governor Charles Evans Hughes eventually became Chief Justice and had in fact been an Associate Justice on the Supreme Court before becoming Governor of New York. So the trivia question for our next show is this: who was the first Supreme Court Justice, current or former, to receive a vote in the Electoral College? So say that again: who was the first Supreme Court Justice, current or former at the time of the election, to receive a vote in the Electoral College? Stay tuned for our next show when we will reveal the answer.
Thanks, Tony. That's terrific. Well, that'll do it for this episode of Law and Democracy. Tony and Ned, it was great to be with you. Thank you. See you
Absolutely.
next time.
Great to be with you, Steve and Ned.